All right, I want to welcome everyone to enforcement of your floodplain ordinance. As I talk to floodplain administrators, this is the most popular question. They often ask me, how are we supposed to enforce this junk? And rarely do they use the word junk. But this is what I get asked most over of all the things that we talk about. And I am Chuck Chase. For those that don't know me, I've got my bachelor's in education and in mathematics from Peru State College, and I got my master's with the National Graduate School in Falmouth, Massachusetts. I'm a certified floodplain manager, and I'm the outreach coordinator for the Nebraska Department of Natural Resources. So as we talk about enforcing your ordinance and we're talking about violations, what is a violation? And there can be all kinds of violations, but typically it's either unpermitted development that's in the floodplain, or you've permitted the development, but they're not following the permit. Something that I stress quite a lot, though, is that of your floodplain ordinance anyway, ugly is not a violation. We can look at this shed here and we can probably find a bunch of violations if this is in the floodplain. We can see that it's not vented in any way. We can see that it's not made out of flood resistant material. It doesn't appear to be anchored in any way. But unless you've got some sort of other regulation, some sort of other building code that prevents eyesores, ugly is not a violation of your floodplain ordinance. Now, as we're talking about violations, we want to talk about ways to bring these structures into compliance. And if the building is insured and it gets substantially damaged, that insurance comes with a $30,000 rider to help bring it into compliance. It's called the increased cost of compliance rider. And the ICC, the increased cost of compliance money, allows for 4 different ways to bring a structure into compliance, and they call that FRED: flood proofing, relocation, elevation, or demolition. So relocation, this option is available primarily for non-residential buildings. It involves making the building watertight through a combination of adjustments or additions of features to the building that reduces the potential for flood damage. Wet proofing of an area below lowest floor has been used for residential structures, or even the crawl space for residential structures, and that could bring a residential structure into compliance. But dry flood proofing, which means that they're making it so the building wouldn't allow more than 4 inches of water during a 24-hour flood event, that's only allowed for non-residential structures. So there are some ways to use flood proofing for residential structures, but primarily flood proofing we think of for businesses and other non-residential structures. Relocation, simply moving the building out of harm's way. We've seen houses, we've seen big houses that have been picked up and relocated. So we know that this can be used, but it can easily be used for a structure that doesn't have to be moved very far, or maybe a smaller shed or something that's easily moved. Elevation. Well, this raises your building to or above the flood elevation that's adopted by your community. Sometimes we only need to elevate the utilities or maybe a portion of the structure in order to bring the structure into compliance. And demolition. This is really used more for substantially damaged structures where more than 50% of it is already damaged. And so you're just knocking down the rest of it. But it could be an affordable way to bring a low-cost building into compliance. And this one is not a part of FRED, but it's possible to just modify a development or even a structure to bring it into compliance. Of course, elevating, flood proofing, those are modifications, but there are other modifications. If a non-residential structure maybe has some sort of drainage thing going right down the middle, and it's the bottom of that drainage that makes it the lowest floor, just filling in that drainage might be enough to bring it up the 1 or 2 tenths that it needs to be brought up to be in compliance. Sometimes removing a deck or an addition. Maybe some houses have this dugout canning cellar underneath it, and filling in that canning cellar wouldn't be that big of a deal as far as, loss of function for the house in order to bring the whole house into compliance. Modifying the earthwork to provide better drainage, elevating pipes at river crossings, anchoring sheds or stored products. Like in one of the communities, somebody brought in a whole bunch of railroad ties and put them right there in the floodplain, just upriver from a brand new county bridge. If there was a flood, those ties would go right down there and possibly block the flow and maybe take out the bridge, if they piled up there. They need to be anchored, and sometimes anchoring is all that needs to take place in order to bring something into compliance. Or adding a few feet of freeboard to berms of maybe a runoff lagoon, something like that. So we want to talk about what kind of legal action you can take to stop development that's not permitted or the like. And as you can see, many of these topics that we just talked about, many of these options to bring something into compliance are very drastic. It's of course better if we can go on ahead and, before we get to that point, make sure that the structure is built compliant than to take a non-compliant structure and trying to make it compliant. So before we discuss these legal tools that we're going to be talking about, here, let's first talk about some of the soft hand tools that you can use to persuade somebody to be compliant. The first thing I want to talk about is knowing your ordinance. When someone is violating the ordinance, or they want to build something out of compliance, they can sense uncertainty on your end. Knowing your ordinance and what is required and what is allowed will prevent some people from trying to get away with something they shouldn't be doing. So having that confidence that you know what's in the ordinance, you know what's allowed, what's not, will come across when someone's coming on in looking for a way to get around what they're going to need to do. Listen and empathize. Sometimes constituents can be downright obnoxious. They can be insulting. They can be arrogant. Remember, they are your customer. And contrary to popular belief, the customer is not always right, but the customer is always the customer. So watch your body language. I might be listening to you just fine right here like this. My eyes might be scrunched down together because I'm very focused on what you're saying, but it doesn't come across that way. The person talking to me feels like I'm not listening anymore, that I've already made my mind up, that I'm cold, that I put this wall up. So watch your body language. Try and be open with your body language and listen to them. Really listen. Stephen Covey says this quote, and I really like it. He said, "Most people do not listen with the intent to understand. They listen with the intent to reply." So hear their perspectives and empathize. And remember, when I say empathize, empathy does not mean capitulation. Sometimes people just want to be heard. Sometimes people just want to vent. Sometimes people will work with you when you really didn't think they would. after you listen them out. So keep in mind, the goal here isn't to get back at a rude constituent. It isn't to teach them a lesson or to discipline them for their bad behaviors. The goal here is compliance. So how do we listen and empathize? I've got a good empathy statement here. You could say something along the line of, look, I understand, Joyce. And I think that if I was in your shoes, I might feel the same way. So what can we do to make this development compliant? You're hearing her, but brings back down to the fact that we've got to stay in compliance. So I hear you, I hear what you're saying. So what can we do? How can we make this compliant? That's one tool. Listening, showing empathy. If just listening to them out isn't enough, even sometimes the worst of your constituents might not have any empathy toward you, but they might have empathy toward others in your community. Nobody wants to be the villain who wears the black hat. So you can use empathy for other people that are in your community. Now, I want to caution you, don't try and use empathy for the community or for the government. You might want to say, look, our people need flood insurance. Your neighbors need flood insurance. We have to stay in compliance. But you probably don't want to bring out the facts about, hey, we need this so that we can get public assistance money or something like that. Pointing out that the community might not get grant money for infrastructure repair tends to translate in, if you do this, I don't benefit. My office doesn't get free money and we'll have to work harder to get things done. It makes the discussion kind of you against them. And that's not the point here. Here's a good statement for empathy for others. I understand, Frank. I know you don't need a loan for this, and I know you don't need insurance for this. You want to move forward, even though it's a violation of our ordinance. But Frank, if we don't comply with these regulations, we could get kicked out of the National Flood Insurance Program. So what about your neighbors, the ones that have to have this insurance to keep their home loans? What about that young couple that just bought the Jenkins place? They need flood insurance for their loan. And what about your other neighbors? If we aren't in the National Flood Insurance Program, their property will be worthless. They'll never be able to sell because buyers will never be able to get a loan. You don't want to see that. Our community needs to stay in compliance. What can we do to keep this development compliant, Frank? So that's a good way to bring in the neighbors, being a part of the community and everything like that. Now, if none of those things work, one acronym that we hear quite a bit is WIFM. What's in it for me? It is possible to go on ahead and look this constituent in the eye and say, here are the advantages for you. If you build this house in compliance, there's less chance there's going to be a loss of life, less chance that when your grandkids are coming on over to visit and there's a flood that one of them might get caught up in this flood and pass. Loss of life, loss of property. It's going to keep your structures safer. And you could also go ahead and pull out the insurance tables and talk to them about how much cheaper the insurance is going to be for this structure if it's built in compliance, rather than if they build it, a foot below the base flood elevation or whatever they're trying to do. Unfortunately, discussing the loss of life or property hasn't usually proved very effective, because if the owner believed or cared in that, they wouldn't be trying to violate the ordinance now. But it's worth a shot. Sometimes none of these will convince, and you'll end up needing to take action in court. So the question is when should you begin to prepare for actual legal action? Well, today. today. If not today, maybe yesterday might be good. When should you start preparing? Absolutely. Right after this class is over, I think is a good time to be preparing for legal action. What I'd like for you to do is to go on ahead and get a hold of your jurisdiction's legal counselor today, if possible, just if for nothing else, just to set up an appointment to talk to them about enforcement of your floodplain ordinance. When you're talking with them, explain to them why it's important for the community to stay in good standing with the National Flood Insurance Program. Explain about how your constituents need to be able to buy this insurance. That public assistance and other grant money is tied to your good standing with the NFIP. That public safety and liability for allowing development that's hazardous to the owners in the community could prove very costly to the community. You need to talk to this legal counselor about different legal tools that you may be able to use, that you might not be able to use, but talk to them about what you have already on your tool belt and what it would take to get some of these tools on your tool belt. Things like stop work orders, which we're going to be discussing, cease and desist orders, which we will be discussing, temporary restraining orders and the like. Talk to them about the importance of enforcing that's your part of the deal, that the government's providing the federal flood insurance and your portion is to adopt and to enforce this ordinance, to enforce these rules. Talk to your legal counsel about how to collect evidence and what this counsel will require in order to take action in court. They know what they're going to be comfortable with, and they can tell you about the things that they need in order for them to feel comfortable taking this before a judge. Your legal counsel also knows the judges, and they know what these judges are looking for, so they can give you better advice about what you need in your jurisdiction. They'll know what they need in order to feel comfortable, in order to prosecute, and regardless of what they say. I think they would amen this one anyway, but document. As things are going through, make sure that you're documenting everything. Seriously, if there is only one thing that you can take from this hour-long class, I would consider it a success if you have this conversation with your legal counsel. Collecting evidence. So evidence is typically in the form of documents, site plans and the like, or correspondence, whether that be by phone or emails, and pictures. So make sure, with your phone calls and stuff like that, keep a good log of your phone calls and correspondence that way. Make sure that you keep your emails and that you have those accessible. Maybe create an email file in Outlook or something. If you use your own phone to take pictures, you need to realize that then your phone can be subpoenaed and studied. All the pictures on your phone can be studied. So I really recommend that you use a company phone, whatever your jurisdiction has. Use a company camera, I'm sorry. You can use the company phone too, as far as I'm concerned. But use a phone that's associated with your jurisdiction rather than your own personal one. Log the pictures that you take. Put down what day and time it was. You can do this in a separate book. Some phones, of course, can log that right on the picture itself. But it's good to have a separate book and to log these pictures to say, what the date and time was, where the location was where you took this picture, what the angle of the shot was. Maybe you're standing on the corner of 8th and Elm Street and you're facing the northwest, Put down what the weather is, any other information about that picture in that photo log. So ensure that pictures adequately show the violation and possibly contain something to show perspective. Now this top picture here, they showed that this building was way low down the bank. They've got this chain link fence that gives some sort of perspective on the height of this building, how big it is and the like. So they've tried to do as good as they can with this first picture. The problem is when this picture goes to court and the defendant is asked, well, sir, is this a picture of your shed? They might say, I don't know. I have a gray shed. I bought it from, some of the Mennonites out there on the highway, but anybody could have brought a gray shed. This could be anybody's shed. I don't know that it's mine. And that could really put some, embed a question into the judge or whatever it should. It should get them questioning whether you're showing this beyond a reasonable doubt. Now, I encourage you then to start off with an establishing picture, not just a picture of the violation. Notice this bottom picture here. This is a picture of the area. This is what we would call an establishing picture. You might note that, if I can get my cursor there, you might know that the street address is written on the side of the building. It's got this nice little deck here, the driveway, paved street. You've got a fire hydrant right here. This picture, this tree here, these bushes, these trees in the background. This can't just be anybody's house. Start off with this picture. Is this your house? Pretty hard to deny that one. And then you can go to the picture of the shed, which is shown in this picture. So we've talked a little bit about collecting evidence. And so now we're going to move on into some of the tools, some of the legal tools, some of the legal actions that you have. And one of the things that you're all aware of, because you guys all know your ordinance so well, is that you have that section in there about fines. Your ordinance states that a violation of the ordinance is a misdemeanor and punishable by a certain amount of money that your council had decided on. Usually it's somewhere between $300 and $500. I've seen things as low as $100. I think I've seen things as high as $800. I don't know that I've seen $1,000. But each day is a separate offense. So therefore, it's very important that you document when you first notified this constituent of the violation. Now, again, this fine is not really to get a lot of money or to punish the offender. Kind of like what we were talking about before, what we're looking for is compliance. So the main purpose of a hefty fine is to get the offender to come to the table, to encourage them to bring this development into compliance. So really this fine is the best use of this fine is for compliance purposes when it's stated like in a letter, requesting the developer to come to your office and to discuss the permitting of this project. Another thing that we've already stated here is that this fine is for a misdemeanor. A misdemeanor is a criminal offense. So you can't just slap a fine on them and say, hey, this has been out of compliance now for 100 days and it's $300 a day. So we're looking at $30,000 in fines, come and pay it up. It has to go to court. You think about a speeding ticket where you pretty much just pay it, but even a speeding ticket has to go to court. You can sign that thing waiving your right for court, but you have that right. So this is a misdemeanor. Therefore, the offense must be presented to a court and the burden of proof falls on you and your jurisdiction. Must be demonstrated beyond a reasonable doubt and before any fine can be imposed. Another legal action that you can do is a stop work order. Now, this is a nice tool when development is taking place or it's soon to take place and it doesn't comply with your ordinance. Now, the thing about a stop work order is you must have authority granted somewhere in your community statutes in order to issue such an order. It's probably not in your floodplain ordinance, but it's probably somewhere else in one of your other ordinance granting the authority for issuing a stop work order. So with that other statute, there will more than likely be strict guidelines in place on how to employ this tool. So that's another good discussion to have with your legal counsel is, do you have this tool? And if so, how can it be implemented when you need to? Now, similar to a stop work order, but more difficult, is a temporary injunction. Now, this is a court order to stop and maintain the status quo until there has been a trial or a court action. A temporary injunction is granted based on evidence presented to a judge. Now, the evidence may be in the form of an affidavit or live testimony along with different exhibits. The defendant is also allowed to present evidence, and an injunction will last until there's a trial on the merits of this dispute. So this isn't a quick fix like a stop work order. Another thing can be a temporary restraining order. Now, this is very much like a temporary injunction, but without a formal hearing. A temporary restraining order is obtained only from a judge. So you can go, your legal counsel can go right to that judge, submit affidavits. It's typically issued for a limited time until there can be a hearing on a temporary injunction. Similar to all of these is a cease and desist order. Now this is like the above things that we've talked about, but it doesn't have to be handed down by a court. It can be handed down by some agency. Your planning commission could have the authority to give out a cease and desist order. It's for a specific activity. And of course, if your planning commission has the authority to do it, that has to be authorized somewhere in some ordinance within your community. So they have to have that authority granted to them by some statute that your community has. So they have to have that authority. It has to be spelled out. And of course, along with that, it's going to give the restrictions on how that needs to be handed out. So here's how things could look. When there's something going on that shouldn't be taking place, either someone's starting building in the floodplain and they don't have a floodplain development permit from you. If you have the ability to give a stop work order, you can go ahead and put that stop work order on it right away until the planning commission meets. The planning commission can go on ahead and meet and they can grant a cease and desist order. Now, if this person doesn't stop, even after the planning commission has given a cease and desist order, then that violation could go to court with a suit asking for a temporary injunction. So that's how these things, how you could use multiple tools for one situation. So that's how these things could be used. Once again, and I'm going to say this over and over again, if this is the one thing, but talk to your legal counsel to develop the tools and to develop that kind of action that your legal counsel wants you to impose. It's going to go a lot further with a judge showing that a cease and desist order was given and they continued working. It's going to go a lot further with a judge to say, hey, we tried this with a stop work order and they ignored it, or something along that line to show this violation. Now, withholding the occupancy permit or certification of compliance. This is a nice tool for someone who's gone on ahead and they've just blown you off and they built their structure anyway or whatever. But the problem here is that this doesn't do much good if you don't have an occupancy permit or if you don't have some kind of certification of compliance. In other words, if you don't have planning and zoning, like Jeff, I know Nemaha County doesn't have planning and zoning, so this isn't even an option for you. There's no tool like that in Nemaha County or Richardson County. So you've got to have those things in place already. You've got to have some sort of planning and zoning regulations in order for you to withhold these things. And if you're going to withhold them, you have to be authorized by your jurisdiction statutes in order to do it. You can't just do it. There has to be some sort of authority that gives you some sort of written thing in one written line in one of your statutes that gives you the authority to withhold this occupancy permit or the certification of compliance. This next one, refusing to turn on power or water. This would be okay for new structures. Even where I live, the little town of Malcolm, you know, they control the water. They don't control the power. Jeff, going back to Nemaha County again, or Auburn anyway, you know, Auburn has their own power company. So having a good working relationship in Nemaha County with Auburn Public Power might give you this ability to say, look, this was built in compliance. We can't turn the power on for this house. Or if it's inside a community where you're running the water, you know, the water cannot be, you cannot turn on the water until it's brought into compliance or something along that line. But it must be authorized by your building code and or any kind of other provisions adopted by your local jurisdiction. You must have some sort of solid standard operating procedure between you and the power company, between you and the water company if it's separate from the county or from your jurisdiction. Even if it's within your jurisdiction, even if your community runs the water, you still should have a solid standard operating procedure. You must be authorized within your ordinance or other statutes in order to do this. And the bottom line here is it's not going to work for additions. They already have water in their house. They already have power, and you won't be able to shut it off. Talk to your legal counsel about that. It's also not going to help any for earthwork, or if they're storing railroad ties along the floodplain or something along that line where they don't really care about water or electricity. This next one, notice on title or deed. I don't know anywhere in Nebraska where we use this. So if you're planning on using this, this is a good one to talk to your legal counsel about how you would implement this, or if you could implement this. This is used extensively in Kansas. What this is essentially used when they lose in court. There's been a violation. They did stop work orders. They did everything. They took this person to court, you know, and said, hey, you know, this is a violation. This house needs to be torn down, or this house needs to be moved or elevated, or whatever option you had. And the judge says, no, I'm siding with the developer. This house can stay as is. So you've lost, you know, you've lost all your, you're at the end of the rope. So with this, and again, it's most commonly used for cases when the lowest floor of structures below the lowest elevation. But this notice is recorded against the title on the building. And it simply states that the house was built out of compliance with the community's ordinance. It therefore informs future owners of the non-compliant status of this structure by recording that notice against the title. So discuss with your counsel, because the concern might be, you know, that that there might be some liability by putting this onto the title or deed after you lost in court. But on the other hand, you may be liable if you don't post such a notice for someone who's purchasing this structure. They might be able to come back and say, look, you knew that this was built out of compliance and you put nothing in with the title or deed to say that, to warn me before I dished out all the money to buy this house. This notice on deed, it recommends that the property be covered by flood insurance, and it warns that if flood insurance is available, it may be very costly. It could also recommend that the potential buyer speak to an insurance agent to determine the cost before the purchase is made. So by doing that, it doesn't prohibit the sale of the property. So therefore it's not a lien. It just makes the property less attractive to potential buyers. And therefore it creates an economic incentive for this owner, developer, whatever, to bring this structure into compliance. Similar to that is FEMA's Section 1316. Now, this is a request of FEMA to deny flood insurance and other services to a property that's in violation of floodplain regulations. So it's used when all other efforts have failed. This doesn't even have to necessarily go to court. If you've done everything you could and got your package together for a lawyer, and the lawyer looked it all over and said, we don't have enough for me to take this to a judge, and you've got nowhere else to go. You know it's a violation. You're the floodplain administrator. You don't want to see a violation continue because you don't want your community to get kicked out of the program. You can go on ahead and petition FEMA for a 1316 on this structure, used when all other efforts have failed. A 1316 provides a means of economic incentive, just like that notice on title and deed, for property owners to correct the violations. It's a way to take action against an uncorrectable violation that also acts as a deterrent for future violations, because someone's going to see this and they're going to say, well, the Jenkins property got built at ground level. They didn't have to elevate. They won in court. I'm not going to have to elevate either. But knowing that the Jenkins place got a 1316 put on it would be a good deterrent. FEMA reviews the request and evaluates the situation. If appropriate, they'll put a 1316. They'll apply that to the property. Flood insurance will not be available for the structure. It's not just that it's going to be expensive. It's not available. Federal flood insurance. Grants, loans, or guarantees made by federal agencies, such as the Small Business Administration, Federal Housing Administration, even the Veterans Administration, will not be available for acquisition or even construction on this structure. After a flood, no federal disaster assistance will be available to rebuild this structure. Now, if this structure is later brought into compliance, a Section 1316 can be rescinded. You can apply for it to be rescinded. Though it is reported that it's easier to get the 1316 than to get a 1316 removed. It's one of the reasons why Kansas uses this notice on title and deed quite a bit, is because they had some real trouble getting 1316s removed after a structure was brought into compliance. 1316 declaration is generally not filed with the Register of Deeds or with the county clerk, yet it should be. You must have something in your local jurisdiction authorizing you to file such a thing, this 1316. So consult with your attorney on possible liabilities. Section 1316 is the last card to play. It shows FEMA that you're trying to enforce the ordinance, even if in this one particular case, you were unsuccessful.